Today, there was a partisan split over the vetting of the Chief Justice nominee, Paul Baffour-Bonney. It raised fundamental issues about judicial independence, and my guests are going to be weighing in. If you're just joining us and wondering what happened today, it was a big day in Parliament. We all look forward to it. It was a build to be one of those explosive vettings because of the circumstances that surrounded the nomination of Justice Baffour-Bonney and the vetting. It's coming shortly on the heels of the removal of Justice Gertrude Torkornoo, the first time this has happened in the Fourth Republic. So you could imagine that this was setting the stage for something pretty explosive. And so it turned out. The minority today, led by Alexander Fenyo-Markin Osahene, rejected the Chief Justice nominee and they walked out. They sat in there, they asked their questions. In fact, not quite questions, they had a statement to read. The minority leader had a statement to read. He was interjected many times with many objections. And in the end, after several hours, they started at 11 thereabout. As of 2 o'clock, they haven't asked one question. I mean, the committee, one question of the nominee, because of the objections and attempt to read the statement that the minority had brought in. In the end, the minority decided to stage a walkout. So they left the scene for the NDC MPs on the Appointments Committee to do that vetting. So a few things that we learned today as far as the MPP's position is concerned, that they raised the issue about former CJ has 7 legal suits pending, and that have not been heard yet. They accused the nominee, that is the acting CJ, of deliberately delaying the listing of these cases and impaneling for them to be heard. And so they were raising fundamental issues there about fairness, but also possible conflict of interest, because he will be a beneficiary, they allege, of the pendency of the case and delay in these cases being heard. And that issues raised concerns about judicial independence, and they wanted that dealt with, plus conflict of interest, as I indicated earlier. So those were the key things that they raised today, for which reason they had some objections. As we know, it's been 72 days since the Justice Torkornoo was removed as Chief Justice. And so that was a context within which this vetting was happening. But as far as Baffour-Bonney himself is concerned, he has been there as acting CJ for 202 days, quite a bit of time to get acquainted with the system itself that he himself has been part of for 17 years, we learned today. So this man has been there for a long time. And there are many who were very clear in their minds today that it isn't a question about his competence, it's just the circumstances surrounding his nomination that have raised questions about judicial independence. Do they have a case? We'll interrogate that tonight when we sit for a conversation. And we know him. He is 68 years. He's turned 69 in December. So he practically just has a year if he is confirmed. Next year, approaching December, he will be preparing to retire. And then the president will get another opportunity to nominate another person to fill that role substantively. So he doesn't have long to stay on as CJ, because he'll be 70 years, and the 70 years is a mandatory age of retirement. So he doesn't have long, indeed. So really, minority should let him go. Well, but the circumstances were not, as we now know. And then we know the key issues raised during the vetting itself. I'm talking about the issues that Baffour-Bonney articulated and what he stands for on some of the key principles. He advocates that we should move the elections to November, and this is something that we know that the Electoral Commission itself is in favor of. He talks about setting election petition before settling it before January 7, before the swearing in of the new president. That's his position on the matter. And this one I found interesting, establishing a 24-hour courts that will sit at night. Night courts, he called them. And those are his thoughts on some of the things that he will be implementing if he's confirmed. And then he says, very progressively, he wants to use AI to empanel judges. Remember that he's been accused of deliberately refusing to empanel certain cases that favor him. He says, I want to leave that decision to AI to do, so he can focus on the big administrative matters that the Chief Justice will have to pay attention to. Progressive indeed. introduce a parole system that we know happens in the US. He wants to consider its introduction here. He says cases involving former CJ not yet ripe for hearing. And that, for me, was a direct response to the minority accusation. We'll play that for the minority here so we can get their reaction to that, because they were not there before the committee when he responded directly to them, and that the current judicial appointment system, he says, is indeed fit for purpose. His position on that exactly. But he also wants to improve the working conditions for lower judicial staff, something that he's very passionate about, and expand admission to the law school. And on this matter, he is firmly on all fours with the Attorney General too, because they drafted a bill that will do precisely that. So that's a summary of what he said today. But the bigger issue is about the controversy, the judicial independence question, and the contest. Should the Appointments Committee, should they have proceeded with its vetting when indeed there are cases pending challenging the removal of the woman she's seeking to succeed? A question that my guests will weigh in on this particular matter. And indeed, does anything bar the president from appointing, nominating him, Parliament considering him with several cases pending that, once determined, could affect indeed his legitimacy? My guests will weigh in after this. Stay with me. And thanks for staying with us here on PM Express. It's always brought to you by Syntax Tanks. It is strong. It is tough. Also brought to you by Academic Times newspaper, and also brought to you by PEP Student Cabinet Fighter. My guests are joining me for a conversation today on the show. And you may have missed it, but I gave you a summary at the beginning of this. And basically, if you missed it, the nominee for the CJ position was vetted today. And as we were expecting, it came with a fair bit of drama because the minority side, they've already served notice that they were opposed to his nomination and vetting. They had raised issues on the floor of Parliament that the Speaker had thrown out. And so they came to the floor with a prepared statement that started off the day with a fair bit of controversy. John Darko is MP for Swame and legal counsel to Parliament's Minority Caucus, and joins me in the studio. Also joining me in the studio is Mahama Shaibu. He is the MP for Daboya, Mankurugu. Mankarigu. Yes, great to have you. Also a member of the Appointments Committee on the majority side. I'm grateful, Mahama Shaibu. Dr. Sai Kwapon, you know him, he is the John Sai Kwapon. He is with the CDD. He's a Democracy and Development Fellow at the Center for Democratic Development. And Justice Abdullahi is a lawyer. He's been watching this unfold with the constitutional implications it has. I want to start with you, John. So many did not expect you to be there today, but then you decided to go. I want to understand why you decided to go. Was it simply to read that statement and leave?
Well, thank you. Good evening to your cherished viewers. I'm surprised that you are saying that many did not expect us to go, because we hadn't said that we were not going to go.
True.
I think people are just speculating, obviously because of all the issues. But we had every intention of appearing and asking questions. And so we went prepared. I had read some of the judgments of the learned acting Chief Justice. I had seen his profile and I prepared my questions. So were my other colleagues. We were ready to go. And it's just unfortunate that when we got there, the majority leader decided that he would take over the job of the chairman of Appointment Committee and decide who speaks and decide who can say what. He said that under his watch, he is not going to allow the Venerable Osahene Afenyo-Markin to, in his view, breach the rules. And I'm asking myself, really, you are just an MP like us. You just happen to be a majority leader. Who gave you the power to decide which words to use in Parliament? Who gave you the power to decide who speaks? Who gave you the power to decide which words are right words for members of Parliament? I was so shocked that the majority leader arrogated that power to himself. And unfortunately, the chair of the appointment committee roll over and virtually gave him the opportunity so that a statement which would have taken at best 10 minutes to read took about 3 hours because in his view, he won't allow it. And I was surprised that all of you saw that and you're not even criticizing him for that because the chair of the appointment committee is the person who has the right to say that these words are good, these words are not good, I will allow this, I will not allow that. Not a member of the committee.
But a member of the committee can raise an objection.
Yes.
Which
but
is what you
don't say that it won't happen under my watch. You don't make that decision. He said he wasn't going to allow it, and we saw it. It took about 2-3 hours for a 15-minute statement to be read because, in his view, he is a majority leader. So they can do anything they want. And I was surprised. So after going through that, really, what was the need to continue to stay? They had made it clear that our presence wasn't needed. They had made it clear that they were not going to allow us to ask even relevant questions.
No, but
right from the beginning,
you didn't attempt to ask
even right from the beginning, you should see the poster. Okay, so for you, media, there are some of the things you don't even see. Right from the beginning, the chairperson started the introduction. Yeah, you are not part of the committee. Your name will not even be mentioned. And that you're not going to allow anybody to talk. You should sit here in silence.
But he was addressing non-members of the committee.
What was the other? We are members of parliament. Of course, members of the committee and members of parliament appear before you.
You can come and observe. That's allowed.
But you see, that's the point.
What he said,
if there's good faith,
it was in keeping parliamentary practice.
If there's good faith, these things, you don't sit down and shout over them because we are all colleagues. All right. So the mindset was that let's go frustrate them. Let's go make sure that they don't even get a chance to air their views.
But John, this was a vetting where you ask questions on behalf of your constituents, of the nominee, to test his suitability for a role.
Yes.
You didn't ask one question. You came to read a statement and then you left.
No, well, we came to read a statement and we saw that we were not even going to be allowed the chance to participate fully. Because, look, why did it take us almost 3 hours to read a statement? Because the majority had purposed that they were going to frustrate us. Okay? The statement...
But what was it frustrating?
The statement,
the reading of the statement.
The statement you're talking about is allowed. It's allowed for, in most cases, the ranking to give preliminary comments if he so wishes.
But raising objections are also allowed in parliamentary practice.
Well, you raise it in the right manner. You can decide that for purpose of smooth running of the process, you allow the person to finish, and then you can raise your issues. But we saw what happened. Line by line objection.
He was using the same rules.
Line by line objection.
But there's nothing wrong with that.
Clearly, look, you see, what is wrong is that he didn't even wait for the speaker or the chairperson to give him the opportunity to ask the question. This gentleman, I'm sorry to say that, but of course, maybe our majority leader is the leader of the House. So maybe I would dread this gentleman. The majority leader kept interjecting without even the chair of the committee giving him the opportunity. And the chair of the committee allowed it. Imagine if I had done that, I'm telling you, he would probably have thrown me out of the committee. He would have thrown me out of the room. That why am I speaking when he hasn't given me the opportunity? But he allowed the majority leader to, because it served their purpose. Of course, they belong to the same party. I know Bernard Hereford doesn't say that as an independent or impartial arbiter. He is part of the majority, and of course, he's chair of the committee. They had the agenda, and they all agreed that this is what we are going to do to the people. And eventually, they succeeded. So after all that, they had no business staying there. In any case, we had made our case. We had said the whole process should be put on hold, in abeyance, for a while. We had made that point.
So to be clear, you walked out because you felt that the majority side were gagging you.
Yes, we will allow us to make.
They will allow you to make a point.
And you all saw it. Not that we felt. You all saw it.
But this was a vetting exercise.
Yes.
I didn't hear you attempt to actually ask questions of the nominee.
Yes, and I'm coming to it. I'm saying that after almost 3 hours of frustration, okay? And having realized that, one, we had made a point that this whole thing should be put on ice. Not that we were preventing Parliament from performing its duties. We felt that this matter could be delayed until the final decision of the Supreme Court. Now you are telling me that the acting CJ, in fact, I didn't listen to all that. He said the cases for the former CJ is not ripe for hearing.
Yeah, I mean, in fact, I'll play that for you. I'll come to the substantive because I responded to you. I'll come to that.
Hear that.
I'll come to it. I'll play that for you.
Within the same.
I'll come to that. I'll come to that. Let me hear his plenary thoughts on this. But Mahama, his point here today, I mean, which also played out before the committee, and we saw how this all played out. You came to the committee really determined not to allow them to read out that statement.
Well, Evans, good evening, and good evening to our cherished listeners and viewers. Clearly, I mean, the minority came not to ask questions, but they came with a script. Unfortunately, they couldn't mark the script. And so every single act that the majority leader did was clearly in line with the rules and regulations that govern the proceedings of Parliament. Indeed, the vetting committee or the appointments committee is an extension of Parliament. So every rule that you'll expect from plenary is the same rules that are applied over there. And so if you raise issues that offend the rules, the majority leader has every single right to object to that. And what were the issues? Of course, you said we'll come to the
yeah, we'll come to this.
But those were the clear things. If you impugn the integrity of a committee that is not subject matter of the vetting or the appointments committee, he has every right to reject that. So they did not come to the party. They came, rather, when you ask the question whether they had announced that they were not even coming for the vetting, then suddenly they appeared with the script, but that script, unfortunately, they couldn't mark it. And so we did what constitutionally was our mandate. Gave them every opportunity. Indeed, today, if you had sat through, you missed a very golden opportunity as minority to ask the questions that you would have been asking or talking.
Yeah, you know what they say, the minority do have their say, the majority, you have your way. Even with their say, your majority leader kept interrupting them.
They didn't even have a say.
Because you deliberately
did
not want to allow them to have their say.
Of Evans, two beautiful books are what we use in Parliament. The Constitution and the Standing Orders of Parliament. Clearly, these are the books that govern the work of Parliament. So if your purpose is to come and vet, and then preliminary issues having a convention is not part of the rules book. And so when you raise preliminary options, speeches, it should be geared towards the subject matter. But where your preliminary remarks or comments now veer into areas that are not part of the ambit of the appointments committee, then majority leader has every right to object to that. So as a chairman who has been very, very, very impartial, I mean, he's giving you all the rope. Remember, he signed minority leader many times to say that please stay within. But because he was bent on, I mean, just raising the issues, they didn't have any questions to ask. All they needed was to come and read the 15-minute document, which document try to impugn the character of people. I mean, basic principles you and I know in law school. When you cite somebody, and remember when he sat through, he cited Justice Palmer as having led a committee, and which committee's report. I mean, I don't want to use the words that he used. And so those words, our standing orders frown upon those words. Chairman asked you to withdraw that. And those were the genuine interventions that the majority leader was putting across. So Justice Bowman did not have the opportunity, because you have mentioned his name, he ought to have an opportunity to have a hearing. But because the law says that, he cannot have that opportunity. That is why you should not impugn his integrity, indeed as a person, and secondly, as a committee.
No,
and so clearly, they did not come to do any vetting. They had come to disrupt the proceedings of the vetting, fortunately.
Yeah, but what would you have lost if you just allowed them to read a statement and then you can proceed with the vetting?
No,
taking you 15 minutes.
They would have clearly been offending our laws.
But here's the thing, though. The majority leader was not stopped from also giving his side, giving the rebuttal on the back of what the minority had come to do. Why didn't you simply wait for them to wrap up?
When you seek justice, or you go to equity, you come with clean hands. Have an issue. They raise the issue just on a pronouncement that, oh, Mr. CJ, they said, no, chairman should withdraw the word because it's not a CJ. That's procedure. Shortly after, they were veering into non-procedural areas. And so we're just asking them that just stay within the rules. So if he had made his statement, whether it's 40 minutes or 1 hour, without impugning, without veering in cases that are even outside the domain of what we had, nobody will interject him. But when you go, you bring in cases that are pending in court, and our rules say that cases that are pending in court, you cannot raise them here. You cannot mention names of chief justices, ministers, or whatever, who are not there to defend themselves. And those were exactly the things he was doing. And the reason the interdictions came.
Okay.
Majority.
Stay with me. So the minority side then walked out. Let me bring in Dr. Saikop on. Doc, the walkout of the minority, considering how essential, crucial this vetting is in the context of whatever was happening within the judiciary itself, does it affect the legitimacy of the processes in a way?
Good evening, Evans. Good evening to your viewers. I don't believe it affects the legitimacy of the process, but I believe it robs the process of an important element, which is the voice of the minority. I mean, a couple of days ago, they had raised their own concerns, objections. They had called for a possible postponement of the vetting until all outstanding legal issues surrounding the removal, etc., have been resolved. The Speaker ruled on that. Now, prior to the Speaker's ruling, one of the things that I had said on Newsfile was, well, if we quote-unquote wait for all of these outstanding issues to be resolved, what would it do in terms of ruining the process of vetting a new Chief Justice? And one of the scenarios I went back to was thinking back to the 2012 election petition, where I was of the view that wouldn't it be nice if we can resolve it before you swear in the president? But sometimes time doesn't align itself nicely to some of these governance processes. The Speaker ruled, and one of the Speaker's reasonings was that, look, if we do this, then we may be setting a precedent where anybody who objects to a parliamentary procedure can hold it up. And is that sort of the precedent we want to set? So for me, it doesn't delegitimize the process or even the vetting of the new of the Chief Justice nominee. I just think that it robbed the process of something very important, which is the participation of the minority who are part of the governance setup, whatever questions they would have asked and all of those things, to be able to also get their view, disagreements, substantive questions, etc. And the process ends with that bit of a cloud still hanging over it, knowing that we still have unresolved grievances that has ended to even the vetting of a Chief Justice nominee.
And Justice Abdullahi, on that same point, the minority's position is that because of the pendency of several cases before the Supreme Court and one at the ECOWAS Court, the Parliament should not have gone ahead with this particular process of vetting. Where do you stand on that?
Well, thank you, Evans. Unfortunately, I had already expressed my disagreement on this earlier in the morning prior to the vetting, and I had done the same, I think, somewhere last week when the issue came up, that it would be quite preposterous to say that every single litigation that arises out of either the CJ's nomination or any other person's nomination would have to await the decision before progress is made. You literally will grind the entire machinery of government to a halt if that was the case. And that is an impossibility. Nobody can afford that. It is.
But you can also expedite that whole court process, right? Considering how crucial this is. We've seen the court do that before when it has to do with issues of constitutional and national affairs. They tend to adopt an expedited process for it. Couldn't the court
There's
do that?
absolutely nothing wrong in expediting the process, right? Except that it also brings along its own logistical challenges and sometimes the quality of the decision that comes out. You do not. In fact, it is the reason why lawyers would tell you that the judicial processes grind slowly. And the reason is because if you rush into doing that, you end up producing the wrong results. So it has to grind slowly so that it can produce the most appropriate results. And so the quality is more important than the timing. Even though if the two could coincide, then it would be an appropriate thing to do. Essentially, what I'm saying is that it is good if we could have a means of resolving constitutional disputes, particularly when it involves the various organs of the state in particular, because they can never simply wait for other things to happen. Litigation to be determined before progress is made on their issues. That is because of the impact that they make on the generality of all of us as Ghanaians and as people, and sometimes even with our relationship with the international community. So it is important that if we could devise means of resolving issues, that is appropriate. However, until we get to that position, nothing should be a basis to stop the process from going on. That is my position on this, which I have done. It turns out to be the position of Parliament on this subject as well. And I believe that if the minority was on the other side, they would agree with me on this same issue. You cannot simply imagine that. Imagine when, let me remind you, when in the, I think that's somewhere 2024 thereabout, when the imposition of the e-levy tax came up, Haruna Idrisu and one other person went to the Supreme Court, filing an injunction to stop the government from from operationalizing the e-levy. The Supreme Court was emphatic on this issue, that it is easier for government to refund these monies should the state go ahead to collect them. It is easier for it to be refunded than to stop the whole entire machinery of the state from collecting these monies when the law has been appropriately passed. Now, this has been the yardstick at all times in measuring the conduct of the state as against the private interest of individuals in relation to injunctions and other things by way of stopping the public.
And by the way, just on that point, Mama Yaga asked that question of the nominee, and he agreed with the position that you expressed, that indeed the position of the law now, as interpreted by the Supreme Court, is that unless you have an explicit judgment or an order from the Supreme Court, nothing can stop a constitutional body, as in the executive or parliament, from continuing to conduct its business within the assumption of regularity.
Thank you.
But there was
Thank you for the affirmation.
There's a second question that he was also asked, and I want us to listen briefly to Justice Bafoboni, and that relates to the fundamental accusation that the minority had leveled against him, that the cases before him or before the Supreme Court, and you know that because he's the acting CJ, the allegation is that he empanels. and that he allegedly may be deliberately slowing the impanelling to benefit him, and he may be in a conflict of interest position. He was asked that question by Mahama Yaga. This was his response.
The issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases to be heard. Is that accurate? And why would that be the case?
If this statement is made by, with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here.
If this statement is made by a person who is not a lawyer, I will put it down to ignorance. I will say that maybe the person is uninformed about legalities, so I will pardon. But if a lawyer makes a statement like this, I would think that it is populist and maybe downright mischievous. The Chief Justice does not list cases, and please, my words, the Chief Justice does not list cases for hearing. The Chief Justice empanel judges to sit on cases that have been listed. Cases are listed when they are ripe for hearing. So we have listing, we have cases getting ripe for hearing and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed.
The nominee speaking specifically to that accusation. John Darko, your response to that? It says it's mischievous and populist that you made this claim against him.
Well, the Honorable Acting CJ referred to somebody, he said somebody made that statement, a person is not a lawyer. I don't recall who made that statement, but I think the point is that this particular case, when the injunction application, when the matter was filed, I think it went with the injunction application. The injunction application was heard expeditiously, I think either the same week or the following week, and the injunction application was dismissed. And the defendant, which is the Attorney General, went to sleep. Now, of course, it's true that the CJ doesn't list cases, but it's a question of court management, you understand. When cases delay even in the High Court, you can pin that on the CJ because he is the administrative head of the judiciary. And so a matter such as this, you know the interest the people of Ghana have in this case. Are you telling me that if your officers are not enlisting such a case, a year or two, you look on for things for it to go on? I believe that Justice Bafumoni is an honest man, honestly, the way I know him. But it is concerning that, in this situation, you hear the injunction application immediately, and the defendants go to sleep and nothing happens. Of course, we know that the registrar can cause the case to be listed, and that he can get promptings to ensure that this case is heard expeditiously.
Your real suspicion is what? That this has been done deliberately?
At this point, that is
to advance his interest.
I won't put it that way. But at this point, that's what an observer will say. Because look, why is it that? And I heard that from the minority leader today, that even when the Attorney General went for extension of time within which to file their response, they gave them how many? Is it 3 weeks? which normally, doesn't happen. I mean, I think that once in a while the Supreme Court, because the Supreme Court is a very strict place, they are very particular about their rules, the period within which to file your pleadings, you understand. But they were given more time. In all of this, the point really is that a matter such as this must be given the proper attention. Why? We're not here in this country. The last election, the last presidential petition, how long did it take? It took us, I think, about less than 3 or 4 months. We finished. The previous one took us 8 months. Okay? But a land case can stay as long as 12 years, sometimes 17 years, in court. The same country. We hear cases within 8 months. The last presidential election, it was heard within 4 months. So if we want to hear the matter expeditiously, we can do it. We don't have to pretend that we don't have any control and that as and when the registrar lists is when it will be heard.
But do you accept his explanation that he has nothing to do with the listing? It's only when it's listed and the case is ripe that then he is brought into a panel, and that you made the point about observers coming to the conclusion that this is deliberate to advance a certain cause. That is simply unfair to him. He says that can't be the case. Do you accept this explanation?
I'm saying that we have situations where presidential elections, we have been able to finish it, file everything and finish it within 4 months. A whole presidential election within 4 months. And then we've had cases where, sometimes not even land, even criminal cases can spend 12 years, 15 years. So if we want a matter to be heard expeditiously, we can make it, we can do it. So let's not pretend that we are some idle bystanders. This is our judiciary. The CJ sits as the head of the judiciary, the administrative head of the judiciary. And so when matters are delaying, obviously it is fair for people to point fingers at the Chief Justice. Not for me in this case, not probably because he has an interest, but the mere fact that this is a serious matter, this is a matter...
But all matters before the courts are serious.
Why do you think...
Why should he make an exception?
Why do you think that presidential elections petitions are heard within 4 months? We know that some matters are weightier. Obviously, we cannot pretend that they are all the same. You understand? Let's be fair and accord the weight to all the cases as they come. And so, look, if we can hear presidential election within 4 months, then there's no reason why this matter can go on and on and on and not be finished. I think that we could have easily expedited this, finish it before this vetting. But, well...
Yeah, I mean, but the minority have a point, right? I mean, because considering that the outcome of the case, if it's determined, will have an impact on his continued stay in office, indeed, if you guys approve him, it's prudent, isn't it, in his own interest to ensure that this is heard expeditiously. You must be sympathetic to that.
No, I don't think so. So you see,
why would you?
When you ask him to comment on the answer that the CJ, he's acting CJ. Of course, you guys attempted to say that he's not CJ. Acting CJ means he's CJ. So when the CJ answered the question that he does not list cases, you see, he couldn't answer you. So that was one of the accusations. So CJ says that, look,
I don't want to go back and forth with you, so you make...
The court is a process. I mean, sometimes it may even start at a point that he doesn't even know. It is only when it is ripe for hearing.
But he can't say he doesn't know about this case. He cannot say that.
Oh, I'm just talking generally.
Yeah. See, let's talk specifics.
Today it suits him. So he thinks that some cases can be heard.
Yeah, but this
of course,
particular case...
We know that, I mean...
The CJ cannot claim he doesn't know about.
Over the weekend to even hear cases. That is fine. I mean, depending on the weight you put on a case, you choose which one is important or which one is urgent. And so, but for us, I mean, let's be very clear in our minds that there is nobody, no person that can compel Parliament to abandon its constitutional duty. That's the starting point. The second is that the CJ is just faulted for nothing. It has not empaneled. he does not list cases. Of course, after the case is ripe, I mean, if you accuse him of empaneling people or judges that you don't like or you have some other reservations about, that's a different thing altogether. But to say that he chooses to list or not to list a case, that is completely not the case. And so, I mean, coming back to my good friend's point, you see, when we put a political lens to cases, of course, you would say the Supreme Court judge is a political figure. But in doing this whole exercise, if we leave out our political lenses and tackle the issue as practical as possible, we will begin to unravel and to know the true case behind it. And so, for me, I just feel that, look, let justice take its course. Let's not interfere in the work of the Chief Justice. Let us move on with what the rules say we should do. Remember that Parliament, Mr. Speaker, Mr. Fenyomakin, and John and his team, they had filed a motion to Mr. Speaker on this same matter that we are talking about. Mr. Speaker extensively read through what the reliefs were and ruled that if Parliament followed all the reliefs that they were talking about, I mean, any litigant can just get up and stop the work of Parliament. So that did not go. Mr. Speaker dismissed that application. That was the same thing they carried to the Appointments Committee vetting. And the reason we told them, the standing orders say that once a matter has been dealt with at a sitting, and that sitting at plenary, what we do now at the committee level is an extension of the plenary. So once that matter was dealt with at the sitting, you cannot raise it again at the Appointments Committee. So those things were settled. The reason I told you from day one that they did not come to ask questions. And they missed a glorious opportunity, of having to elicit very good information, useful information from a very intelligent and brilliant will-be Chief Justice of this country.
Yeah, I mean, let me bring in Osakwapon on the point. Dr. Osakwapon, on that subject of the cases that are pending before the acting Chief Justice, the claim is that he stands to benefit from the delay. That perception and how this has become such a partisan matter, we all know he's going to be approved. But we have a Chief Justice whose vetting and confirmation it's become so partisan, that definitely will have implications for our democracy going forward, would it not? Because he will be seen as the NDC Chief Justice, unfortunately, because of the way this has panned out.
And, that is also one of my, I appreciated the fact that he, in no uncertain terms, pushed back on that narrative, that some way, somehow, he has some motive for as to why these cases are not being empaneled. For me, for instance, it was a good educational piece for me to understand the process it goes through in terms of right for hearing, listing, and then the CJ and panels. I didn't have that education prior to this. So it was good to be able to share that with the public in very unambiguous ways. But we are also at a time where our institutions are suffering from a twin problem, which I've regularly pointed out. If you look at Afrobarometer, trust is low, perceptions of corruption is high. And so our institutions are trying to find a way to sort of restore faith and confidence in them in terms of the way the public sees them. So when you see these fights, quote unquote, play out, and when you see the partisan angles to it, it only perpetuates that sort of narrative in the minds of citizens. I always ask that, for example, if you disaggregate the Afrobarometer data, you would notice that for those who identify with a particular political party, when their party is in power, their trust in institutions go up. When their party is in opposition, their trust in institutions go down. And it's also the other dimension of the trust challenge that we are facing, right? And for me, the more these partisan fights occur, deep disagreements over constitutional processes, and the reading of all kinds of political motives into what happens or what doesn't happen, the consequences for us is our democracy continues, for me, in my opinion, to suffer this perception that citizens are having about our institutions, which is they can't be trusted, and they can only be trusted if those we feel close to are in power. That is when our institutions give us some comfort. And that, for me, is not a good place for us to be in terms of our institutions.
And just Abdullah, on that point, I mean, today in his opening remarks, the Chief Justice nominee himself acknowledged that the judiciary finds itself at a crossroads. It's a very important moment because of the circumstances surrounding the removal of the previous one and his own taking succession. Isn't that why this partisanship that has now characterized the entire vetting process is such a dangerous occurrence for a judiciary that you can say is actually on his knees? It's never been here before in terms of the trust that he wields in the eyes of citizens. This is a fairly damaging sort of occurrence, right, for the judiciary's reputation, going into a very important period when they will have to rebuild. Justice Abdullah, can you hear me? Okay, I believe he's frozen. I'm going to take a break. When I return, hopefully he can weigh in on that.
Because you're
yeah, Justice, can you hear me?
Yes, I can hear you.
Yes.
Good. So I was saying that I seriously would wish that this matter was handled better than we find it at this moment. Unfortunately, the cracks emerged the moment the previous one was removed and he was nominated. And somehow, he being the second in command also automatically had the burden of superintending over the entire process, taking charge of the administration of the judiciary. So the nominee, I'm sure it was his wish that things could have been handled better. Sorry. The majority could probably have come together and steer this whole affair in a better way. But unfortunately, the removal occasioned the division. And so automatically it was expected that what we witnessed was going to happen. It is a genuinely difficult time. It is very difficult to navigate yourself around, within this maze. But unfortunately, this is what we have. I think he has an obligation to build trust and build bridges across the two sides. I think that would be a better way for ensuring that we have a better and more trusting judiciary going forward.
And then apologies there, you just catch your breath and get some water. I'm going to take a break. When I return, we'll look at the substance of what he says. He got asked a few questions, and he gave us a sense of where he stood on some of the most controversial issues of our time. I'll get my guests to weigh on them substantively. We've dealt with the form of this, which really was important because of the partisanship that had characterized this. A minority standing their ground. But remember, this will come before the plenary for debate and then possibly a vote. The majority obviously has their supermajority, but I'm pretty sure the mighty minority will have their say nonetheless. So when I return, I'll weigh in on that and get them to weigh in on some of the specifics that he articulated. Stay with me. And you're still live here on PM Express. It's on the Joy News channel, and we're talking about what happened today with the vetting of the Chief Justice nominee. Let's talk about some of the key issues that he articulated when he was asked. There are fundamental issues around his belief in holding the elections early. We know it's on December 7. He says do it in November, which is something that the Electoral Commission pursued before. Settling the election petition before January 7 is another one that he believes in. But then establishing a 24-hour court, it's night courts, he calls them, again, to expedite hearings, I guess, deals with something that John himself talks about with John Darko. I mean, that some of the cases can be expedited. Chief Justice says, I want to do exactly that, so the courts will sit at night. And then I found this very interesting, that he wants to use AI to empanel the judges. I thought that was quite interesting. And the parole system that he also wants to introduce, something that the US, we know, does, that he's considering introducing. John, I know you were not in the you're not on the committee,
but he listened
when the questions were asked. But I'm pretty sure you may have heard a fair bit of what he said. Well, Can you give me your assessment of some of his thinking around some of the big issues?
Okay, let me be honest. I didn't get to listen, but when I came here, at least you play some of them. So I'm taking my position, okay, from what you showed me. I think if you take the issues, the setting up of the parole board, for me, it's very interesting because I followed the American judicial system a bit. So when you mentioned, I was surprised because when you set up a parole board, the people who are incarcerated, they come before you based on a lot of circumstances, maybe behavior and all of that, and you give them a parole officer. The parole officer, because it's a supervised release, okay? And I think he's just trying to do that to decongest the prisons. So a supervised release, I'm wondering how that is going to work in Ghana. We have a lot of work to do before we get to a system where we release people on supervision and then have their parole officers. Because in America, parole officers are paid good money. They follow the people. In fact, their time they have to report. And because they have good address system, they're able to trace them. And in most cases, they can give them
monitors.
Yeah. They're like
when you are under parole, they can tell you that you are not supposed to go outside certain diameter, or maybe say 20 kilometers outside your jurisdiction because of the monitor and all of that. How are we going to do that in Ghana? But I think it's a good thing. Maybe you have to start thinking through how we're going to get that. But I don't think that, in all honesty, it can be done within his period. But it's a good thing we need to start with. The question, his issue also with the appointment that he said that the current appointment of the court, there's nothing wrong with it. Okay?
Yeah.
And that he believes that it is okay. Well, I mean, as it stands now, we are going through the constitutional review. There are a lot of people who believe that this has to change, you know. But I have seen that all over the world, Supreme Court judges are appointed by the president. I haven't really seen any issue with that. As to whether, for me, I believe that maybe we should have a constitutional court and then another court. I'm not sure that issue was really...
Yeah, you know, it came up. It came up because it was. Yeah. Because his proposal, and I thought that was interesting, that he says we should actually pass a law that will limit the jurisdiction of the Ghanaian Supreme Court. And, for example, take away and say, for example, something he actually said, that the appellate jurisdiction will be limited to the appeals court.
Yes. Yeah.
That you cannot, appeals court will be where you end if you want appeal. You can't go to the Supreme Court.
That's right.
And he was raising a comparison between the Ghanaian Supreme Court and that of the U.S. Supreme Court. Is it something that you think it's...
I completely agree with that because the jurisdiction of Supreme Court is too wide. So every case goes to the Supreme Court. That is why the Supreme Court is choked. And so that, for me, there was a time we had the Court of Appeal as our final appellate court. So we brought
some years ago.
Yes, yeah. That's what brought the famous Tufon Attorney General case. So
you're in favor of returning to what that?
No. That the Court of Appeal, in some cases, the Court of Appeal will be the final appellate court, and then the Supreme Court will be there to take, let's say, only constitutional issues. All right, so that not all cases will go to the Supreme Court. I think that will help them to deal with some of the most important issues. I think the other one had to do with the number of lawyers. That
he says
expansion of
he disagrees that we're the churning out, and that word was important to him, that the schools are producing too many lawyers. He disagrees. He says they are actually not producing enough lawyers, and so he's in favor of expanding legal education.
I'm not sure how many lawyers really will agree with that, because look, right now my firm, I have too many applications I can't even take. People who want to do pupillage.
But that's in Accra. And he makes the point rightly that they go to the whole Kumasi, they just have like 300 lawyers, but a whole, not Kumasi, but the whole Ashanti region.
Yes. But what makes me think that if we produce 10,000 lawyers tomorrow, they will want to go to Kumasi? They won't stay here in Accra. All right? So the fact that you have very few lawyers outside Accra doesn't mean they'll continue to produce. We really need to, as it were, handle this very well, because otherwise, excuse me, maybe those who have MBA will fight me after this. The law will become like the MBA we have now. Now, people with MBA certificates are tellers at the banks, because they've made MBA so common a course that everybody has MBA in this country. Everybody. And I don't know whether Mama agrees with me, but I think this one he will agree with me.
Yes, I have an MBA.
Everybody has an MBA. And the problem is that
he didn't know you had it when he was saying it.
I had an MBA from Leicester Business School.
Okay.
And a good one like that.
You know, we are losing the value. Now the law school, if you look at the number of people, I'm told, I don't know whether it's true, that in the last admission, they admitted about 1,500 to 2,000, right?
About 1,300.
Well, so let's even go by yours.
But this country is under-lawyered. We just have to find ingenious ways of distributing our lawyers
I think
better.
that we need more engineers and doctors. I agree with those who make the argument any day. We need more engineers and doctors than lawyers. So, you know, in my case, I said that right now, the lawyers can't even get a place to do their pupillage.
Yeah, you can set up your own chamber. You don't have to.
No, you don't. You cannot. When you come out of the school, you cannot.
Yeah, but if you work somewhere else and then afterwards you
So
leave.
where are you going to even work? People are not even employing. Lawyers are not employing, because once they come, of course, once you employ them, you have to pay them. Do you understand? How many people can you take? So now what is going to happen is that people will be called. They won't even get any proper training from any law firm. You'll find a way to get a certificate after 6-7 months, and they say they are lawyers. Look, the quality of the legal profession, if you are not careful, will go down. And I'm afraid that if you are not careful and we continue to go the way we are going, in the next 10 years, we're going to have a lot of ambulance chasing lawyers in this.
But that's interesting. Mama, where do you stand on that?
Well, so on the contrary, I have a different view altogether. From the 1890s up to date, this country has produced only 11,400 lawyers, as against a population of nearly 35 million. So what that means is that every lawyer will be, a ratio is to 1 to 7,000. That is woefully inadequate.
But wait, my brother, just 1 second. Let me. The statistics is that from 2021 to 2024, just within that 4 years, we have produced close to 5,000 lawyers. So you can add that and continue with your argument.
Yeah, but that's what makes it 11,400 in total, as against a population of about 35 million. Now, because you are not there, and that's why I say you missed a golden opportunity of listening to very brilliant submission. He makes the case that every single district assembly, 200 and whatever number, needs a legal officer. That is the work of a lawyer. And all para-institutions are all part of it. And remember, when we say advocacy, the people who go straight into practice, that's law. He jokingly made a statement that, look, that about half of you are even in parliament. You have all run to parliament. Some are sitting in the banks. Some are in corporate world. And so the real ones who are practicing, if you even look at that ratio, it shoots to about 1:10,000. And so I think that legal education, he spoke about it. And
so you're in favor of expanding?
Look, I am seized, as chairman for Constitutional and Legal Affairs Committee of Parliament, I'm seized with the matter. And I am
Has the bill come before you?
Yeah, I mean the draft, I have the draft.
Okay, but has it been formally?
This is the very last time, Evans, that people will queue and write an entrance exam.
Okay, so you are showing, and there are a lot of people who are waiting for this bill.
We will pass that. So that is the starting.
So next year, for those who will be...
The face of legal education will change completely. This is the very last time people are queuing to write exam to go to the law school. It's a completely new reform.
When would it be laid before Parliament?
Immediately, before we go on recess. It will be laid.
So before the December break? Before Christmas
December
break,
okay. The bill will be laid in Parliament, and then we'll start work.
You support that bill, right? Just for clarity. Just a second on name, because that's important. You support that bill?
Well, I haven't seen it. Honestly, it's still in the committee. I'm yet to see.
It's expanding legal education,
but I mean, look,
decentralizing it, taking the monopoly away from the Mokola, correct?
Yes. So let me just go through a few other things.
Generally,
a few other things
you're not
opposed to
okay.
that. But I mean, we just have to be careful. I don't know. My brothers, we need to be very careful.
Okay. No, we are very careful.
Yeah, articulate the rest. Let me get from the
We
rest
have been exceedingly careful. And also about the question about the AI and the Constitutional Court. I mean, I raised that. I asked those two questions. Because of the nature, you see, the Supreme Court is completely packed now because of the hierarchy. And every single thing from the lower court moves to the Supreme Court. If we do the South African style, where they have a purely constitutional court, and they have an appeals court. So other cases will terminate at that, and then constitutional matters are now solely to be dealt with.
So in favor of what he suggested today about the appellate jurisdiction should be...
Absolutely. I mean, I like that. And then
delegated to the appeals court.
The AI bit was also very important. I mean, sometimes to say that there's a human element.
Yeah.
Every judge seated in there has voted one way or the other. Indeed, for Supreme Court, even it's clear that nominations are done by the president, whoever is in power. So what that means is that we have a human hand in this. And once constitutional matters are decided at the Supreme Court, there's a need to free it from the physical interaction and the rest of that. So that's suggestion of AI. I mean, a 68-year-old man who's thinking of technology to use in empaneling just means that there's great future for the judiciary as we move on. So that they use, the system to empanel.
Let me get Justice Sai's view on the substance. Justice Sai, that's Dr. Sai Kwapon. What did you say about the substance you had? What struck you?
So what really struck me again is the issue that has been discussed now, the jurisdiction of the court and all the kinds of cases that can come before the court. You get the sense that it creates quite a huge administrative burden on the court with implications for how quickly or how late a case can be heard. And even more importantly, what that means for how many justices we can keep appointing to the Supreme Court. So any changes that would really, reduce that administrative burden to make the caseload manageable, I believe would really improve the efficiency of the court. I like the fact that he brought up confidence in the courts. And finding ways to restore that confidence in the court. And I want to highlight, under the previous Chief Justice, there was an initiative called Leading Justice. which was going to undertake certain reforms to try and address some of the key issues facing our judiciary. And I hope that even if it's not the same reform program, but some kind of institutional reforms would occur, even with the limited time that he has as a CJ, if he's approved, to address some of those low confidence trust issues in the court as well. The last thing I would mention is I was quite struck by what he said in terms of the sentencing that was given to a notorious armed robber and the consideration of by the time he's out, probably I wouldn't even be alive, or I thought about the safety of my family. I wonder how many judges go through that fear of their personal security or the personal security of their family, and whether certain sentencing guidelines as well as other measures can give them that security and comfort that they don't have to give long sentences as a way of dealing with some of those personal safety fears and concerns.
Yeah, I mean, that point is a very important one, and many have picked up on that, but he expressed it because he's a human being, I guess. It's just the human side of a Supreme Court judge. And Justice Abdullahi, what struck you?
Yeah. Indeed.
Hello, Justice.
His children are the
same. Justice Junior. You know, that's the one that he took to proceed. Yeah, I want to hear you briefly before I wrap up.
Evans, I think you may have to allow this cup to pass me by.
Okay, well, I allowed indeed. Let me then hand that to you on that point about expanding legal education. He agrees that is something that must happen. You've heard the concerns that John Darko had raised about us being careful. Where do you stand on that?
From everything that I've heard expressed, and a lot of my education on the expansion of legal education has come from Professor Kwikwaza. And so I've come to really understand, why these reforms are necessary. But yes, in order to undertake any kinds of reforms, you also have to make sure that you don't create any unintended consequences, and that once decentralized, those who would take up the decentralization of providing legal education also have the capacity to be able to do that. You want to ensure that quality is maintained, standards are maintained. There is some sort of quality assurance system in process that allows you to embrace the idea that these reforms are serving or addressing our needs around legal education. But in principle, I do agree with the idea that expanding legal education would prove beneficial to the society at large.
And then he makes a point about night courts, almost signaling his compliance with the 24-hour economy, no matter how controversial that is, seeing that is a manifesto promise of a particular political party. But you see the vision there. He wants to expedite the cases. Justice indeed delayed his justice denied, they say. And having night courts sound like a very interesting proposition.
Very much so. And sometimes when you think about how long cases can take, so I always use my personal experience in terms of watching my mom go through a 19-year litigation over land, and thinking about whether there are ways in which the court can expedite some of these litigations and resolve them. So anything that enables a reduction of the administrative burden and the expeditious dealing and handling of cases, I will support. So it may not be night courts for all issues, but perhaps there are some issues that we can extend the operations of the court to be able to deal with it, so it frees up other courts' time to deal with other issues. But anything that makes our courts more efficient in the administration of justice, I think it's worth considering.
Yeah, and John Darko, what do you make of that? The night courts, a good intervention by a very progressive CJ nominee.
But I mean, I don't know how deep into the night the courts are going to run. If night courts ends at 6, it's fine. But if you ask me to come to court at 1 a.m., I'm not going to come. So, yeah, I mean, look.
But if your client's liberty is at stake and you can secure a bail at 9 p.m. or 10 p.m., you would go. You'll be very grateful.
Well, again, we always try to look around to see what is happening. Look, in other jurisdictions, they sit throughout, sometimes up to 6. Okay, but beyond that, I don't see that happening. What we need to do is proper case management. Look, we keep, because we've seen it. In the US, when there's a criminal trial, or even civil trial, we come tomorrow, they use 1 week to finish a trial. They can use 1 week every day, and then they are done. But Ghana, the trial can take like forever. So we just have to change the way we are running our system. Look, now we have improved through the introduction of the automated courts.
Yeah.
So that has, and then the other part is that now you file your witness statement. Okay, first you have to come in, sit in the box for you to be questioned. Now you file witness statement. So that has, those things have brought the more or less abridged the time in a way. So we need to find a better way of managing, especially the hearing. The judges can use 3 days. They will come morning and close in the evening, and then they will finish it. It's good, but for me, my worry is how deep into the night we're going to run. If we are asking people to come to court in the middle of the night, how are you even going to protect them security-wise? Look, in our courts, in most cases, we have lights off. Can you imagine you are in the court at 9 p.m. and there's blackout? What are you going to do? So we really need to think through. For me, there are better ways of expediting actions or issues or court cases than going deep into the night.
But bottom line is, this is going to come to plenary. Your minority, you participate in that debate, and would you vote if it comes down to that?
Yeah, I mean, but look, so that's a good point, because you stated that we boycotted the vote. We did not. We were part.
No, you walked out.
We walked out.
Boycott.
He didn't say boycott. Say you walked
out. Okay, well, maybe I've seen that around, that people felt that
we walked out.
No, we walked out. We still reserve our right to come there to debate and then vote. And we've expressed our opinion. We'll go and debate the report, and then we'll take a vote. We have also expressed our intention to vote no, and so the report will be a majority report. It's part of our democratic tools. But the beautiful thing is that today, I was proud of us. I mean, Ghanaians, that we can disagree in this cordial manner. There's a little bit heat here and there, and we all go home. Look, me, this brother, if it's not too late, we could just get down there and go and drink tea. We can disagree and still, move together as a people. I was proud of us as Ghanaians. This is not the first time, and it's obviously not going to be the last time we're going to have some of these tensions. Let's continue to, in my view, improve what we are doing. We have the opportunity to make our democracy the best and the envy of the world. Right now, our democracy is on trial, but in the next 4 years, at least the next 3 years.
And Mama, very briefly, as for you, this is a straightforward matter. You have your supermajority. This will come before the House. Is as good as approved.
Very straightforward. And again, let me make this very clear. So when you say minority and majority report, it does not mean MPP and NDC.
Yeah, of course.
So a majority report just means that majority of the members. So you can have 3, 4 MPP joining to say that we agree with you on this.
And you can have some of the NDC people also joining us.
Yes, it's not about, partisan sort of thing. Clear. So tomorrow we expect that they join us again, because we have to sit and take a decision on this before we conclude.
But they walked out. So.
Yeah, they walked out. But they are still part. They are members of the committee.
But you need them to in the drafting of the report.
No, so we need them to decide. Once you are done, you take a decision as you report to plenary, whether it is a majority decision or a consensus. So these are the two things. Okay. So tomorrow we do a meeting, then we take that decision and then conclude the report. They still have, opportunity to have their say as we'll give them some space to debate on the floor of Parliament, and eventually,
thank you very much.
It's a done deal. So
yeah, it is. Thank you very much. Enjoy the rest of the evening.